So how are you, Sarita? What, introduce yourself a little bit. I saw you over at Bally's webinar also.
I'm doing well. I'm here in the US. I'm in Florida. I am a trainer, scrum master, and
Oh,
a coach. And most mostly I do it seems to be I'm trapped in it. Not it's not a bad thing. It's just where I am. I do training for veterans because I'm a veteran in my field. So
yeah. The link just went on. Hey, Ton, how are you?
yay, I hate people are showing up.
Indeed.
Yes.
Just a small problem.
Just a
No,
minor problem. No link to show.
yeah. Yeah.
It
It happens. Best laid plans. Yeah. Um, Well, I've got quite a bit of the audit tool worked out, but it's one of those things where the sum of everyone's experiences is better than the sum of one.
Yeah.
Oh,
Does the audit tool cover both the front and back end, the prompting and the response aspect?
yes, you will see that when I have it. When I have it broken down into sections. So there's governance. Programmatic AI governance goes into one section, and then you look at things like security and privacy, and then you look at the things that are more ethically aligned. So they're all like bunched into sections, and there are multiple different questions per section, and there are ways to gauge the strength of the evidence as provided for answering each one of those questions. And that's where I'm going to require a lot more help is in defining how wants to determine what is good evidence for answering these questions, because it could be industry specific. If you're in banking finance, is it something that is covered by a regulatory agency like OCC, FDIC? Is it something that is included in a regulatory schema like GLBA? So there are privacy implications throughout Gramm-Leach-Bliley Act that need to be taken into consideration that are not specifically AI, but AI bumps into them all the time. So there are areas that will definitely need help in understanding what that evidence that can be presented, and also the questions. There may be some that the team will come up with that I would never have thought of, but at least I have the overall, just using this term loosely, the overall framework for the audit tool laid out. And hopefully there's someone with some development experience that can put this into a web form. We can bring clients in to the web form to do their assessment and provide them with the response. And what's great is that you can automatically generate the response if it's through a portal, and you can use that response as a springboard for not only helping the client to improve their scores, but also to use them as a comparison for their peers or near peers within their
Mm.
industry.
Thanks for coming to our webinar today. We're speaking on the topic of preserving the privilege governing generative AI in law firm workflows. So we're going to talk about AI in law firms and where some of the unique characteristics and requirements of law have begun to really bubble to the surface, particularly in the space of AI governance. And we all know that attorney-client privilege is commonly referred to as the oxygen of the legal practice. And generative AI is really a powerful tool that is being utilized now to impact legal AI, legal proceedings. So ultimately, the goal is to keep the oxygen flowing while we work faster and smarter through deploying AI in the legal space. But again, being mindful that legal has some very unique aspects and characteristics with respect to AI governance that need to be accounted for. And there are other industries in a similar vein, like the medical healthcare industry and finance. So let's talk about really a circumstance that happened that really wrought this whole notion of use of AI in a ineffective way, how that has legal ramifications. A breach that billables can't really fix, can't throw money at it. So there was a recent court case, Matta versus Avianca, in the Southern District of New York, where Judge Castle fined two lawyers and their law firm $5,000 each for citing 6 hallucinated cases in a trial, and which resulted in this cash penalty. But more, the case really serves as a stark warning that AI misuse can really lead to significant professional consequences that go far beyond whatever fines and monetary sanctions there might be, in terms of the reputational damage to both the attorneys and the firms, to say nothing of their clients who could be severely impacted by a loss in the case or the case being dismissed, et cetera. And clearly no amount of billable hours can really adjust this and deal with this. So let's talk about where the slide says where secrets slip. And that's where the use of AI can inadvertently, in some cases, expose privileged data in AI work streams that could be accessed people that shouldn't. One of them is intake chatbots. We've all seen those on various websites now, used in customer service purposes, where if we entered client information into these intake systems, this data may be logged, it may be stored and potentially subject to discovery if it's not properly secured, could be subpoenaed. Research prompts, legal research queries or prompts using a Gen AI LLM that could contain confidential case details, which can compromise privilege when entered into these systems. Drafting copilots, document generation tools that may retain privileged information in logs or create discoverable records of client communications that again can be deposed or subpoenaed. And discovery pipelines, where even if you host a model on a lockdown LM Studio server, like even a legal LLM for that matter, that's contained within your network, you can still lose a attorney-client privilege if the prompt or usage logs are kept and again are subsequently subpoenaed. So all of this means is that it's a much more all-encompassing aspect of attention and protocol and discipline that have to be applied in the use of AI, particularly the legal setting. Here's a snapshot of some of the sanctions and some of the monetary fines that have happened to date. That it's actually more pronounced in the UK. The UK has adopted a similar hands-off stance to AI governance as the American federal government has, although in the US, the individual states are still allowed to put to law AI governance and compliance and controls, even if the federal government doesn't, as that was stricken from the recent tax bill that went out. And these numbers are only growing and will continue to grow. So let's take a look at what does governance really mean for a law firm. And in our pyramid, it starts with some of the traditional guardrails and protections in the legal space in general. Ethics rules, ABA formal opinion 512, and in New York City bar option of 2024-25. These are just a couple of examples. They're really pervasive in all states and on a much bigger level with the Bar Association. Then we have technical guardrails, zero retention APIs. So if there are exchanges of data, it's not logged, it's not recorded, it's not hanging out in ether space somewhere that somebody can access. Encrypted logs that can't be hacked. And then number 3, in the risk management space, this is where we get more into looking at the NIST AI framework and govern and map functions. And then finally, through ISO IEC 42001, the notion of continuous improvement, creating an AI governance plan, and then implementing that, and then checking at various intervals to make sure it's working and it's enforced, and then acting finally by purchasing ongoing certifications and annual reviews. This is the plan, do, check, act loop that I'm sure many of us are familiar with. So what does AI governance cost? This is just a guesstimate, but for a mid-sized firm, you can figure and plan on about $20,000 a year through various aspects. There might be a quarterly subscription and annual audit. So somewhere in that vicinity, but for a law firm, that's just a handful of partner billable hours for the kind of security and peace of mind that AI governance can provide in their business. So now is the spot where I'm actually going to keep doing some work in addition with AI agents. So I just want to take a moment to share an app that we're working on in conjunction with governance. This is one of the apps that our group is looking to really put out there in the hands of law firms, because it will implement guardrails and it will be a tool that can ensure their use of AI has the necessary controls in place and compliance in place. We built this just quickly. Here's a case dashboard. The TrialLift product is really to help attorneys prepare, trial lawyers prepare for their trial cases using AI to assimilate documents into a repository, commingle that with public LLM or private LLM data to forge basically a trial strategy, a winnable strategy, taking into account also who may be the judge on the case and how they typically rule on other cases that are similar. So we have the ability to upload documents, even from various document sources, such as a network drive. Although I don't know why this is spinning around there. Various document sources. And then we can run our AI analysis using a series of quick prompts, canned prompts, summarizing medical history, if it's a malpractice case, finding negligence evidence within, again, peering into that LLM of case trial documents, assess witness credibility, and you can write custom prompts and then store them. And then through legal research, you can access either public LLMs or private LLMs. There's a number of private LLMs that are available through third party that you can upload to an LM Studio type product. And again, you enter your query, you can save your queries, and then basically start your research on that. And it will respond back with, in this case, ChatGPT 4.0, and it's basically doing a prompt, using the prompt above to act on that. And again, we have judicial analytics on the judges, how they typically rule in similar cases. Success metrics is our dashboard view. We have an export center where you can export basically case files, analysis into any kind of format and create a formalized report. And then this last piece here are our guardrails, where you can input a test prompt, and behind the scenes, we run it through our guardrails and protections to identify any PI or client-related data. So that's just a quick view of, one example of where AI agents can really support the legal industry, being, again, mindful of what the governance requirements are within the auspices of legal. And so thank you for that sidelight. So again, as I mentioned, in the EU in particular, there are much more stringent, as a consequence of the recent EU AI oversight law that was passed, much more stringent requirements. For example, in the UK, they have high court standards now that can issue contempt threats if AI verification determines that there has been a misuse. Recent rulings also indicate a zero tolerance for AI hallucinations in legal filings, with judges explicitly warning against contempt charges and proceedings for future violations. And then in the space of GDPR data transfer limits, Europe's strict data protection regulations impose additional constraints on how client information can be processed through these AI systems. And cross-border data transfers from country to country must satisfy additional safeguards that may not be required in the case of purely domestic or U.S. matters. So there's a lot of moving parts here, but it's safe to say that, especially in particular the EU, there's a greater acknowledgement of the challenges AI governance presents, if not implemented. Counting the cost, again, we indicated the investment might be $17,500 to $20,000 a year. The risk could be in the millions based on potential malpractice liability. Through some of the AI tools like the agent we showed you, there could be a reduction in research and trial prep time anywhere from 30% onwards. So we'll talk a little bit about life cycle monitoring and model updates. As we know, AI governance, similar to cybersecurity, where you're constantly refreshing definitions of malware and viruses and so forth, the same vigilance must be applied in AI governance. AI governance does not freeze at the initial implementation, but has to watch every version change in all of the touch points, all of the AI elements that are involved. The federal standard NIST in the US urges continuous risk measurement. And recent ACC ethics briefings have warned us that silent vendor fine-tunes can reopen privileged leaks overnight. We know that many of the public LLMs are consistently referred to as a black box. We don't really know what's happening when they do a significant update. And because of the extraordinary velocity in which AI products are being updated, in particular, where you have Anthropic versus OpenAI versus other players in the space, this becomes a really heightened and critical piece because the changes are happening and in a significant level. It probably dwarfs the kind of changes we deal with Microsoft's automatic updates, but it's the same kind of principle. Just as an IT department has to monitor patches and fixes and make sure that no violations and further deployment can be exploited, in the same way, AI has to be carefully monitored. So through real-time monitoring of these model weight changes and automatic alerts to the compliance team so that they can dig in on this. And similar to security and networking requirements, one-click rollback capability if it comes down to that. And version comparison for risk assessment. In the same way with software releases, you have release notes that can identify what's changed in the revision. Again, a lot of this is targeted towards the whole black box notion of the public LLMs and documentation of all those model updates, such as I mentioned, release notes or the equivalent. So what should your Monday morning checklist look like in the AI governance space if you're the person so tasked with that at an organization? You have audit prompt logs. You should be persistently reviewing on a daily basis every AI system in use for retention settings and verify that logs are being properly configured to minimize privilege risks. Examine all the prompt history in the user logs. If you have people in the organization that are persistently violating the prompting protocols, there may be a training issue. So you will go back to them and try to nip that in the bud. Verify that minimum retention periods are enforced and that data is cleaned out after that, and implement automatic purging protocols as an extension of that. Renegotiate your vendor contracts. Make sure that all of your agreements with AI providers explicitly forbid data reuse and ensure that privileged information always remains protected. Add non-training clauses for client data to ensure that the LLM isn't retaining that and learning from it. Require prompt definition, notification rather, of data breaches. Again, similar to the network security space. Establish vendor liability for these privilege violations. Build into your contracts risk and reward if necessary. So there's skin in the game for your vendors in the event of a violation. And number three, I alluded to this previously, there's a term in the legal space called lazy associates. Those are the ones that use ChatGPT with generic prompting to come back with the case law that supported their trial, only to find that they were all hallucinated. So working with associates, working with really everyone in a law firm to understand independently that they need to validate not just their outbound prompting to protect against data being exposed, client data being exposed inadvertently, but when the returns come back, to make sure it's, of course, free of hallucinations, but all of that return information has been verified and vetted. And one example of that is being a former journalist and remembering all the president's men, where Woodward and Bernstein were constantly being told by Ben Bradley, you got to get a corroborating witness. Yeah, we're not going to go out on a limb because one person says XYZ about Nixon or his inner circle. We need someone to corroborate. And it's the same way in AI. Make sure that you have citations and multiple sources corroborating the information that comes back. And document the verification process. What is that process? So that in case you get audited, you can show that you went through the steps. And create accountability for AI-assisted work product. Make sure that whoever's requesting it is applying the right guardrails to ensure that that data is not circumspect. Because if privilege collapses, who's going to trust us? If we expose or violate attorney-client privilege in their information, the client's going to go somewhere else. Or worse, as we discussed earlier, there may be legal ramifications and financial ramifications from that. Future negligent claims may target firms that refuse to deploy vetted generative AI or governance. And as AI adoption becomes a standard practice, and we know from statistics that more than half of law firms today, even small and medium-sized law firms, are starting to dip their toe in AI, that the firms that fail to implement proper AI governance may face claims of negligence for falling behind the standard of care or missing critical legal precedents or inefficiently or incorrectly representing their clients in a case, or worse, failure to protect their confidentiality. All of these can have catastrophic effects. So let's talk a little bit about the ISO IEC 42001 in action within Contify. That's a critical baseline indicator in this constant, again, we talked earlier about the plan, do, check, and act. But ISO 42001 is an ongoing capability that continuously monitors AI governance, starting with your plan. Again, develop policies and procedures for AI that protect attorney-client privilege, implement controls, and again, train attorneys on proper AI usage for both prompting and research work. Check, put quarterly audits in place, automate your risk perspectives, as we discussed earlier, monitoring prompts and output, putting protocols in place to manage those, and act. Spend the money to work with an AI governance to be certified in that space and invest in it just like you would in cybersecurity. And we talked a little bit about this in our other webinars. Cybersecurity is now probably 15 to 20 years in its evolution. But we all remember back in the early days, firms that lost their shirt because of a computer virus or malware or ransomware or whatever. But there's been a lack of adoption really for AI governance, other than those obvious top tier players, but even they are still shaking out where this all plays out. But in the small to medium-sized firms, there's a lack of awareness as to why AI governance should really even be in place. And that's step one. Is there's 5 levels of marketing in terms of a potential client. And the top level is a client that doesn't know they have a problem and doesn't know there's a solution. And right now, that's probably more than half of the people in the legal space, especially in smaller to medium-sized law firms.
Richard, I think it's fantastic that you mentioned that. I just want to put an asterisk down here. It's worth putting a case stand down that we happen to hang our hat on for the 2001. It's superior for a lot of reasons. But as with any great governance solution, that this cycle be respected as a cycle. So often leaky governance, whether or not that's AI governance, information governance, privacy governance, corporate governance, is treated as we get to the spot and we stop.
Yeah.
But law firms of all sizes, clients of all sizes, all industries do need to understand that a control like this must be a cycle. It must be a cycle.
Yeah, which is why we have this nice little graphic to remind us exactly that we have to plan, do, check, and act. And again, we talked a little bit earlier about the EU AI Act on traceability and transparency, which is specifically targeted towards AI governance. This act commands high-risk systems to maintain automated generated logs for at least 6 months to enable regulatory tracing of decisions. And legal AI applications are increasingly categorized as high risk because of their potential impact on the fundamental rights and access to justice. So again, think about that a little bit. If AI can impugn on the justice system and process, that's more than just dollars and cents or someone's lost credibility. That could be life impacting, or that could convict people who are innocent, etc. Our compliance approach is to use encrypted metadata, hash log metadata stored for regulatory minimum of 6 months in the EU case, and prompt purging, raw prompt content deleted after 30 days to minimize exposure. And this architect marries the GDPR data minimization principles with traceable requirements, protecting privilege while ensuring the regulatory compliance is in place. So to conclude, we'll talk a little bit about incident response and vendor oversight. What happens if there is an AI breach? First of all, and this is very similar to network breaches or, again, cybersecurity breaches, a very similar kind of protocol. This will all look very familiar. First is there's a detection. Automated systems will then continuously monitor for unusual data access or processing patterns that might indicate a privacy or a privilege breach. Then next, there's a 4-hour internal triage period and assessment and containment measures that get implemented ahead of both whatever the regulatory and client requirements are. You kind of circle the wagons and do that initial assessment, how much damage is done, what parts are touched, where we should start thinking about the resolution. Then the 24-hour vendor notification. Contracts typically mandate that the vendors alert us within 24 hours of any kind of compromise or breach, following Deloitte's CISO guidance or incident response. And then that 72-hour GDPR window, where a complete incident response playbook is aligned with GDPR 72-hour notification requirements, ensuring that there's full compliance. So the incident response process is designed to address AI-specific privilege breaches with the urgency that they really demand, which will keep us ahead of both the regulatory requirements and ultimately the client expectations. So that's our presentation. Thank you very much for listening. And we're entering into, I think, a unique phase. Everyone talks about AI as the biggest impactful tool in our generation, perhaps even our lives, and at the incredibly accelerated rate that it's offering things. And now we're into AI 2.0, which is what we're talking about in terms of deploying agents, AI generated solutions, whether they're through agents, MCP servers, or no code, low code tools and applications, to ensure that these have the necessary governances, guardrails, and security in place as well. And that, again, as we mentioned before, these AI applications are changing, evolving so quickly, much faster than even Microsoft software or Google. How do we keep up with that? How do we keep the strict protocols in place to ensure, essentially, similar to cybersecurity, that customers are not injuring themselves by not following proper protocols? So we'll open the floor up to any questions. At this time, I'll stop sharing. And just a reminder, too, if you'd like to join our AI governance community at Cognify, there's a link and we'll send this deck out to everybody. So thank you.
Thanks, Richard. That was awesome. A lot of really good information there. I was a little curious about the short demo that you gave. Is that something that you put together yourself?
Yeah, I built that in Replit with a developer as my sanity check.
Okay.
And yes, and it's designed really, we're talking with particular personal injury firms where that's a big component of them is trial preparation. Winning trials and the financial rewards attached to that is their bread and butter. But they're all concerned, as you can imagine, about using, in particular, public LLMs to supplement their discovery or case files within that kind of environment. So yeah, we built an app that will either survey their existing case documents in whatever case management system they use or make a copy of it, but also allows them to commingle, as I mentioned, with either private LLMs using a product like LM Studio and pre-existing legal databases to, again, use the predictive analysis aspects of generative AI to win the case or point out where the flaws, the gaps are in their evidence, witness proceedings, and so forth.
Are there opportunities that you're thinking of for TrialLift to be able to connect into larger studios that currently exist, like Epic and there's another one. It just flew right out of my head, that are designed for legal case management, discovery, contract analysis, evidence analysis, et cetera, et cetera. Are you working on making any functional connections between any of those currently available tools?
Yeah, we look at the necessity of integrating within trial management platforms, trial management systems, because we don't think it's a good idea to simply duplicate all of the documents, and certainly in an external capacity. And there's no real reason for it. The onus of identifying what those documents are. And there are tools out there. There are AI tools out there that help law firms to assimilate their various document types and formats into their case management system. So we would be peering into that and definitely looking to interface with those systems, as well as this one particular system that's out there that does all of the document consumption.
Yeah, even from an architectural perspective, I think the replication of data from multiple different points is really not necessarily the most efficient and effective way to manage data. It leaves you with an ambiguous architecture, for one thing, and it also adds multiple different replication points that could fail at any given time. So I'm always a big fan of virtualization whenever you can apply the technology. And with artificial intelligence being what it is today, there's no reason to not use some sort of data virtualization technology, like something like that, to make it a lot more architecturally streamlined. But even from a legal perspective, the more endpoints you have, the more replication endpoints you have, the more you've just opened up your discovery profiles. Not necessarily the best.
Right. Even though in the product, we basically showed that, yeah, you have the ability to create your own repository should you choose by either uploading documents or going to a network drive, Google Drive, whatever. But we realized the best case scenario is to just tap into the case management software and get access to the documents there. And that has some benefits too. There's if they do use a product to pre-screen to inboard or onboard their inbound documents that apply metadata,
Mhm.
assign the client matter, the attorney, all the various team members. That's valuable information that we're not going to glean if we were just doing that. So it makes much more sense to just leverage, to your point, what these other tools are doing. I think what we're doing that is unique, hopefully, is the predictive analysis part. Again, in a lesser price point for small to medium-sized law firms who may not have access to Westlaw, Nexus, Lexis, Bloomberg Law, we
Sure.
can still give them either private LLMs or even Gen AI LLMs to look at that information, but enforce guardrails around the prompting and the responses back. Of course, sure.
Are you also thinking of integrating with DSPM solutions like security with an eye, where they already have some very well thought out, very well designed LLM firewalls for both input and output so that you can actually assure who has access, or you can assure what's going into, what data is going into and feeding an LLM. You can ensure what's going out and back into from the internet to any large language model. And you can also have assurance as to who has access to the output of those models. And it does maintain logs. So if you're thinking of connecting into a DSPM solution like that, so that you can ensure maintenance of logs, and I'm at a loss for words today. I don't know why, but
Yeah, you're good. I think I know where you're going, Todd.
yeah,
For what it's worth, that first off, that's all brilliant.
That's a great idea.
That type of alignment is something that marrying of good AI governance posture, good AI management, and data governance, because that's probably the term that's close as I can get without copying everything InfoSec's doing, is something that's very important that a lot of folks are starting to put out there. But there's a lot, as I think you've heard me say before, and you're saying now as well, that there's a lot of solid governance on the InfoSec side that dovetails very well into that, especially these posture management systems, the DSPM systems, that this type of approach, this type of framework is a foundation for good governance. And I have found, we're just one firm looking into this, but in my travels so far, there's still not enough of a conversation putting out practical advice on marrying these two, where really it's getting a sports car with a beautiful finish and not having the garage to store it in. Figure this out.
For the example I always use, it being an audiophile, your audio system is only as good as the weakest link. So if your turntable sucks, that's going to have a major impact, regardless of how good your receiver, preamp, and speakers and all the other pieces are.
I can belabor that analogy. Having a good AI system is like good hi-fi. Having good AI governance is like being able to say, hey, it hits these frequency ranges, and this is the sweet spot for your hearing, and it has this certification. And if it's not put on a decent power grid that's noisy and has brownouts, which is your InfoSec governance, you're going to have a bad time.
one point and then one question. So remind me if I forget to get to the question. I think what's really interesting is, and this is what I'm seeing, and these are the conversations that I'm having with a lot of people who are really putting a lot of thought into AI governance, is that AI has given us the Rosetta Stone. It used to be where when you walked into an organization, you looked around and you noticed how each individual function was functioning, security, risk, compliance, legal, ethics, IT, they're all in their own little worlds doing what it is that they do, largely because they hadn't had something that made them all work together. And artificial intelligence is one of those things that's given us the kind of like the Rosetta Stone that says, here's the same language that we need to speak, and we need to work together to make all of this work and deal with the risks that are involved, deal with the compliance issues that are involved, deal with the security issues that are involved. And we hadn't really seen, even information governance has not really done that as well as it's promised. And the reason why is because there hasn't been the solid end or set of end use cases that says this is the reason why we need to work together. And AI has given us that kind of North Star, Rosetta Stone, whatever you want to call it. And I'm seeing a lot more cross-functional conversations now than I ever have before. And I've been doing this I've been in IT management for over 30 years, but specifically in data management and data governance, it's been about 20 years. So this is more, I'm seeing more cross-functional conversation now than I've ever seen. So now the question, Richard, what's your favorite speaker?
Who's my favorite speaker?
Yeah, manufacturer of sound speakers.
Oh, yes. I've had Vandersteins. I forget what I have, but they were too big for my little apartment. But I love Yamaha. I have a surround system in my house, our tiny little house. The Yamaha 7-channel sound system, a Rega turntable. I know that with amps and receivers, what's making a comeback along with vinyl, which is great. I have hundreds and hundreds of records from the old days. But yeah, what's making a comeback is the receivers and amps with tubes. The analog is making a comeback.
The reason why I
Someone
asked,
actually started another factory making vacuum tubes.
yeah,
I've heard that. Yeah.
yeah. So the reason why I asked is because my dad, and I thought you could see it, but you can't see it. It's behind that music stand behind me. It's on the wall. My dad was the chief architect for Jensen, the speaker.
Yeah.
Yeah.
I know them. Sure.
Yeah, so he was an electrical acoustical engineer, and there's a plaque on the back wall over there underneath. Underneath that painting, which is something that we. But anyway, there's a plaque on the wall behind me that is from one of his patents through Jensen when he was the chief architect there. So,
Awesome. New company. I'm sure at some interval, I've had some Jensen speakers over the years. I've had many different brands. Bose, of course, comes to mind, and many others.
if you ever had a Ford that was manufactured sometime in the 70s and 80s, then you had Jensen speakers.
Ah, okay. Yeah, I think my parents did. Yeah, for sure. Yeah, that's interesting. Oh,
Yeah.
small fact. One of many fun facts you seem to have, Todd.
This may be a pleb answer, but I'm going to put Sennheiser out there. That's still in.
Oh, yeah, they're still around.
All right.
Yeah. Yeah. Just,
That's a really good point. I'm glad that there are more of these, as you mentioned, cross-functional conversations, because again, the most obvious parallel is to cybersecurity. There's just a lot of overlapping there, and cybersecurity depends on InfoSec and many other touch points too. It has the training element and the networking components, but it's interesting to think that AI really will involve all of them because it's so pervasive and overwhelming.
Not to wax too futuristic, and maybe this is a sign we're probably at the close of the presentation, but just Todd, hot take. How soon do you think we're going to get computational encryption, which would solve a lot of this?
That's a really good question because they've been working on, what is it? It begins with an M or an N. It is a type of encryption that is used specifically within the analytics world. and it does not require that you decrypt the data before you actually use it to perform analytical functions. And there's a word for it, and it's very computationally heavy.
I think I know what you're talking about.
Yeah.
Mhm. Sounds vaguely familiar. Yeah.
I remember hearing about this and going, okay, that's not computational encryption though, but I'll take it.
No, it's not. But they haven't even figured that the one that I'm talking about out
Yeah.
yet. So once they do, and the one that I'm thinking of is also very computationally expensive. I'm sorry, go ahead, Richard.
Yeah, I was going to ask you a question. I know we have just a couple of minutes left. It was actually a question that came up coincidentally on another AI program I was on, where she was talking more about the prompting protocols. And that is, where do you think blockchain is at what point will blockchain intersect with AI? Because maybe that would resolve, especially the anonymous aspect.
Yeah, then I mean, when we were talking about morality the other day, my point wasn't an anti-capitalist statement. It was more along the lines of, don't look to an economic system to give you your foundation for morality, because you're not going to find it there. There are schools of thought that have tried to look at economic activity through a moral lens, and hey, more power to you. That's great. And I applaud that. But economic systems can provide opportunities for immoral acts. And when you start talking about adding blockchain into AI input and output operations, then there's a more than even chance that it's going to be used for some
Less than that, to sure.
yeah, seriously immoral activity, unfortunately. But
And of course, given its blockchain, it would be very difficult to track.
to track exactly. Hey, I do have another meeting, so it's an awesome conversation, gentlemen. I really look forward to next week.
Thank
Tomorrow, and I'll talk to you later, Chris.
Yeah. I'll see you tomorrow. Thanks, Todd. Appreciate you.
Thank you. Same here.
All righty. All right. I guess it's that time to sign off. Thank you for those of you out there who either watched this or maybe watched the recording. Again, don't forget, alternating Wednesdays at 1, we have a webinar series in our consistent approach and focus on AI governance and all the different touch points. And we'll have some specific conversations about various industries and various aspects. And then on alternating Wednesdays at 6 p.m. Eastern, we'll have panel discussions on some of these things. We'll bring in people like Todd Henley, who's obviously an expert in this space in data governance and beyond, to have really informed conversations around AI governance, which we're preaching to the choir of how important it is and how, how we need to really promote the importance of it and the education around it, and not fall victim to the same things that may have happened to us in the infancy of network security and cybersecurity. There's no reason we have to feel the pain and deal with this after someone gets run over. Let's start thinking about that today. So thank you, Chris, for the opportunity to present today, and being, as always, my partner in crime on this, and happy to be along for the ride.
My pleasure indeed.
All right. Thanks, everybody. Have a pleasant day, and God's blessings with you always.